to Work This Way, a labor and employment podcast. I'm Tina Emerson, here today with Maynard Nexsen attorney Christy Rogers. Good to see you, Christy.
Hey, Tina. Always great to see you.
You too. Today we are joined by two more members of the Maynard Nexsen Labor and Employment team, Laura Mallory and Ashley Parr. And today we're going to talk about the role of employment counsel in corporate transactions. When the topic of mergers and acquisitions come up, people think about corporate lawyers being involved in the transaction, but don't always think about employment lawyers. Can you tell us what the role of employment counsel would be in a situation like this?
Sure, I'm happy to take this one. So employees and therefore employment issues are really a part of every transaction, regardless if it's a stock deal or an asset deal. So let me break that down. So generally speaking, an asset sale is the employment relationship is terminated and a new one is created with the buyer. So that means the seller needs to do all the things an employer typically does when terminating employees. So that means you're thinking about payout of final wages, is any accrued but unearned vacation pay owed. There's other issues too, notice of termination, stay bonuses, severance provisions, all that could be triggered in an asset sale as well. So it's important to be aware of those requirements. On the other hand, a stock sale, there's a continuity of employment. So you don't need to worry about those things about triggering final pay issues or severance provisions, because essentially the buyer steps into the shoes of the seller. So it's important to make clear in the purchase agreement what entity is on the hook for what, right? So for example, in an asset sale, it's important to figure out if you are in a state where an employer has to pay out accrued but unused vacation, who's on the hook for that, right? And so I looked in December, I think we have about 13 states that require that, right? So based on the number of employees that the seller has, that amount of liability that it's owed for payout of vacation pay can be staggering, right? And so it's really important to make sure it's determined in the purchase agreement who's on the hook for what. But regardless of the structure of the deal, really it comes down to employment liabilities. And so you need to do a meaningful diligence. And so the goal of that is to figure out what are the obligations and liabilities. And so to do that, it's important to figure out, are there any active lawsuits against the seller? Have there been any threatened litigation? Have there been any charges with any state or federal agencies, right? And the other hand of that is, while there's not any threatened or active litigation, it's important to look through the seller's employment practices and figure out, is there any potential liability based on that?
So obviously when we're thinking about one of these deals, we've got a buyer and a seller, right? That's kind of it at its most basic level. So when we talk about employment counsel being involved in the deal, is it more important for the buyer to have employment counsel do this due diligence and look over everything, or is it more important for the seller to have employment counsel, or is it both?
So I think it's both, right? I think it's important for L&E counsel to be involved on both sides of the deal, but candidly, I think it's really more important for the buyer to make sure they have competent L&E counsel, because it's really the buyer that's at risk for inheriting various liabilities, right? And all litigation can be expensive, but certainly employment litigation for two reasons. One, because of the risk of class and collective actions, right? Meaning you're not dealing with one or two plaintiffs. You could be dealing with hundreds, and class actions can easily cross the 7-figure mark, just depending on the size of the class and the issues at stake. And two, there are multiple employment statutes that are drafted. So an employer may also be on the hook for the employee or the former employee's attorney's fees. And that can also get very expensive. So it's very important that a buyer is well aware of those potential risks and liabilities that could result in litigation.
Tell us more about some of the specific issues that can happen with employment in a merger or acquisition.
Yeah, well, in theory, it could be a really long list, but the most common issues that we see are misclassification of workers as exempt for purposes of minimum wage and overtime requirements under the Fair Labor Standards Act or similar state laws, and then misclassification of workers as independent contractors. So claims brought by employees who have been improperly classified can result in significant liability, including liability for unpaid wages and benefits, liquidated damages, unpaid taxes, attorney's fees, like Laura mentioned. And like she also said, these claims are often asserted as collective action, seeking damages on behalf of all affected employees. But when we're working on a deal, other issues beyond those two really common ones that we might identify could be other improper pay and record keeping practices, such as like timekeeping requirements, bonus payment practices, and the effect of both of those on the calculation of overtime. We might also see noncompliance with pre-employment and hiring requirements, like related to drug test or background checks. State laws vary greatly on both of those subjects. For example, many states restrict an employer's ability to make hiring decisions based on certain aspects of an applicant's criminal record, and also very specific laws regarding documentation and consent required before running background checks. So those, and then another issue could be employment eligibility and immigration law compliance concerns. So due diligence, that process should cover the seller's practices for ensuring immigration compliance, including the use of Form I-9, potential use of E-Verify to confirm prospective employees' eligibility to work in the U.S. And then also, along the lines of something Laura mentioned earlier, we'd be on the lookout for specific contract provisions and employment agreements. We'd look for change in control payments that are due, severance obligations, for example, other things that might pop up in agreements. All of this is, again, not an exhaustive list, but just some of the more common issues that we might see.
So if we've got a company that wants to throw caution to the wind and they decide they do not want to have an employment lawyer, kind of do all the things y'all have been talking about, what are some of the risks to the employer for not engaging employment counsel to take a look at these issues?
It's all about issue spotting, right? And so if you don't have an L&E lawyer involved in this, it's very possible you don't know what an issue is, so you can't spot it, right? In thinking about this, there was an example that we had where we had a deal involving restaurants in various states. And many states allow employers to require tip pooling, which essentially means that employees subject to the pool have to chip in a certain portion of their tips, and then that's divided among other employees, right? Some states allow that, some don't. And some states that do have very strict requirements regarding what must be in place in order to have a lawful tip pooling arrangement. So during the L&E diligence review, we caught that the seller was not in compliance with one of the state laws, one of the states that they were operating in. Specifically, that state did not permit tip pooling. We alerted, in that situation, we were representing the buyer. We alerted the client, and actually a class action lawsuit was filed within 2 weeks of us noticing that. And I think so, therefore, in that specific example, if we were not involved, clearly they would have been tipped off because of the lawsuit. But I think that serves as a great example of an employment issue that a non-L&E lawyer might not have spotted, right? So it's all about just being aware of the potential issues and making sure you have someone that is able to spot them.
Yeah, and some of these classification issues, like I was talking about, they can be tricky, even for skilled employment counsel. And even you may have the best corporate legal team there ever was, and they just could possibly overlook incorrect classification and pay practices. So that's why we like to be involved if possible.
Well, in doing that due diligence, I'm sure this happens often where you have a buyer and a seller, and you've got a company who is buying a company, and you discover that they have misclassified a lot of their employees. If they have done that, where you've got someone who is an exempt employee but should be non-exempt and getting overtime, what do you do to mitigate that when a company is coming in and they want to reclassify how these employees are listed on their payroll?
So when you're going through this process prior to closing, first step, you got to make sure during that diligence process that the legal team has all the information at play. Fact and document gathering is so critical to that diligence process. So before we can really do anything, we've got to really evaluate the risk. We've got to understand the employees, their day-to-day roles and duties, how the company's been paying them, and that might involve reviewing job descriptions, pay records, so on. So from there, we evaluate that risk, likelihood of liability. Is there a clear violation of the law? Is the seller company maintaining that they really have complied with all employment laws? And this is just a gray area, leaving only a slight risk of liability. But either way, assuming that our client wants to go through with the transaction, and they typically do, we would, again, pre-close, work on revising the representations and warranties in the purchase agreement to ensure that they very specifically address the issues where we see the potential liability. In this case, proper classification of the employees under the FLSA. And then along with primary corporate counsel, we make sure that the seller would be obligated to indemnify our buyer client if any claims or complaints arise post-close about pay practices or any other employment issues. Bottom line, if a lawsuit is filed down the road after the transaction has closed, challenging the pay practices, we want it to be, if we're representing the buyer, we want it to be the seller, not our buyer client, who would be on the hook for any damages or cost. And then post-close, moving forward, you can make sure everything's done correctly.
And with that indemnification that you were talking about, tell me a little bit about that process, Christy, of how that works when a company is buying another and they want to not be held liable for mistakes that have been made by the seller.
Yeah. Well, the devil's in the details, right? And it's all about the contract and how the contract is written and having the parties come to an agreement, and we put a specific provision in the agreement that talks about indemnification and specifies the instances in which the seller agrees to indemnify the buyer. And like Ashley was saying, if we've already identified, these particular things that we know could create some potential legal risk, that's one of those things that we would specifically delineate in this indemnification provision, such that if, as the buyer, we ever got sued, because remember, what we're talking about usually with pay, a lot of times in misclassification is going to be a claim under the Fair Labor Standards Act, which is the federal wage and payment law. And that has, it's kind of a assumed 3-year look back for any wages that might be due. Sometimes an employer can reduce that period of the look back period or the statute of limitations to 2 years if they can demonstrate there wasn't a willful violation of the statute. But because if we buy the company and then employees begin to complain about, hey, wait a minute, for the past 2 or 3 years, I wasn't paid correctly, we want to make sure we've delineated it well in the contract that if we as the new buyer, as the new owner of the company, if we get sued for that, this seller agrees they're going to indemnify us, which means they're going to step in, they're going to deal with the defense, they're going to pay the cost of that litigation, they're going to pay the cost of any settlement, that has to be paid in order to get the litigation resolved. All those issues, they understand, even though they're selling us the company, they maintain full responsibility for everything they did prior to the closing.
And that's why you're extra diligent during the due diligence period,
There you
right? Exactly. Well, thank you all for being here today. Laura, Ashley, Christy, thank you very much. We will see you next time on Work This Way.